right, good. Well, all right, good evening, everyone. I'm Amanda Betts. Tonight, I'm going to talk with you about a problem that has really been bothering me since I first learned about it when I started in this program 2 years ago. Now, suppose that you are a warehouse manager. You've been interviewing candidates for a second shift warehouse job. In each interview, you carefully go over all the requirements of the job, the days, the hours, break schedules, dress code requirements, everything that you can think of. You finally select Joe. He's the perfect candidate for the job. 2 months into Joe's employment, you learn that he has been having attendance problems. Joe has left work during his lunch break every Friday since he started. Your company has a zero tolerance policy for attendance problems during the first 90 days, so you have no choice. You fire him. A few weeks later, your HR director informs you that Joe is suing your company for failure to accommodate his religion. Wait a minute. What religion? What just happened? Joe never mentioned a religion. He just up and left every Friday at lunch. How can Joe sue you for failing to accommodate a religion that he never told you about? Unfortunately, the way the law is written today, this scenario is a very real possibility. So tonight, I'm going to discuss why the law would allow this to happen and what Congress should be doing now. Now, Title VII of the Civil Rights Act of 1964 is the law that prohibits employers from discriminating on the basis of a number of protected characteristics, including religion. Title VII also requires employers to reasonably accommodate employees' religious practices as long as that accommodation does not cause undue hardship for the employer. Now, for several decades after Title VII was enacted, when a religious accommodation case came up in the legal system, the district and circuit courts would hold that employers cannot be held liable for failure to accommodate a religious conflict if they were not first aware of the conflict that needed accommodation. That changed in 2015. That year, the Supreme Court heard a case between the Equal Employment Opportunity Commission and Abercrombie and Fitch. An Abercrombie store had refused to hire a young woman named Samantha Eloff because she wore a headscarf that would violate the company's dress code policy. Samantha was a practicing Muslim, and she wore her headscarf for religious reasons. Now, Samantha never explained the reason that she wore the headscarf to her interview that day, nor did she indicate that she intended to wear it while she was at work. She didn't mention it at all during her interview. The hiring manager had seen her as a customer wearing it before, and the manager knew a friend of Samantha's who was also a Muslim. The manager assumed that Samantha wore it for a religious reason, but she did not clearly know that. And nonetheless, after a discussion with another manager, the Abercrombie team determined that they could not hire her because the headscarf violated their dress code policy. Now, when the district court first heard this case in 2011, they determined that Abercrombie was at fault. The hiring manager correctly assumed the reason for Samantha wearing the headscarf, and in the district court's eyes, that was enough to show that they knew the practice was a religious one. When Abercrombie appealed, the 10th Circuit reversed the ruling in 2013. They said that knowing is not the same as correctly assuming. And since Samantha never asked for an accommodation, Abercrombie could not be held liable for failure to accommodate. The Supreme Court took on this case to answer that question about knowledge. And in their final ruling, the Supreme Court clarified that Title VII does not actually include a knowledge requirement. This means that employers can be held responsible for failure to accommodate, even if they have no indication whatsoever that an employee has a religious conflict with the work rule. Now, this has really muddied the waters, so to speak, for religious accommodation cases. On the one hand, employers already know that they cannot directly ask questions about an applicant's or employee's religious preferences. But on the other hand, how can employers be expected to balance their duty to accommodate with that inability to ask those questions? Employers now are being encouraged to develop a formal process of notifying employees and applicants about all workplace policies that may interfere with a religious practice. But is that really feasible? According to research by procon.org, there are more than 300 documented religions and denominations just in the United States. How is it possible for employers to anticipate every potential conflict? What happens if an employee has a conflict that the employer did not anticipate? These are among the questions that employers are now faced with. And now that the Supreme Court has ruled on this issue, the only remedy is an act of the legislature. Congress should amend Title VII to include a knowledge requirement for religious accommodation. This would get employers out of the reactive position they find themselves in today and put the courts back into the position of considering real notice and real knowledge in these cases rather than ambiguous concepts like assumptions and suspicions and hunches. Now, in the final ruling of the Abercrombie case, the Supreme Court compared the language in Title VII to the language of the Americans with Disabilities Act, the ADA. The ADA was enacted in 1990 to provide discrimination protections for disabled Americans. The ADA also requires employers to provide reasonable accommodations to disabled employees who are covered under the Act. It's important to note that reasonable accommodation that is required under the ADA is only for employees with known disabilities. As the Seventh Circuit stated, the ADA does not require clairvoyance, and this is what the Supreme Court was pointing to in 2015 when they compared the two statutes. Now, was the Supreme Court alluding to the idea that Congress should address this? I can't say that for sure. While the final ruling never specifically mentioned an amendment to the law, several of the concurring and dissenting opinions did allude to the idea that knowledge is best practice. And this is why I believe an amendment to Title VII to clarify a knowledge requirement is not only a logical, but a necessary change. Now, do you remember our warehouse employee, Joe, from earlier? As it turns out, Joe is a practicing Seventh-day Adventist. As part of his religious practice, he is unable to work between sunset Friday and sunset Saturday. This is why he seemed to abandon his second shift job every Friday halfway through his shift. Now, you didn't know this about him at the time. And with the current state of the law, you could potentially be in a lot of trouble in this scenario. But with a clear knowledge requirement for reasonable accommodation, this scenario would look a little different. Joe would have been required to inform you of his scheduling conflict at the beginning of the process, which would have given you an opportunity to work with him to accommodate. Even if Joe still had chosen not to discuss his conflict and this case went to court, a judge could easily determine that you had no knowledge of his conflict and therefore no reasonable expectation to accommodate. If Title VII were amended to include a knowledge requirement, employers would have an easier process to follow. The courts would have clearer direction when considering these cases, and employees would have a better path to ensuring that their personal religious needs are not in conflict with their jobs. Thank you.